Hello everyone, today we are looking at a courtroom hearing that is a little difficult to follow because of the audio quality, but there's still a lot happening behind the scenes. This case involves a bind-over hearing where the judge must decide if there is enough probable cause to send the case to circuit court for trial. We will explain the legal process, break down what is happening, and see how things unfold when courtroom arguments do not go the way people expect.
Here you have people. We're here by special appearance, Your Honor. We made an honor not to argue, but to challenge authority.
Your name?
Showman Robert Lewis.
Okay. This is the date and time set for a preliminary exam. Mr. Showman appears here on his own. As we've done in the past, Mr. Showman, I need to make sure you understand your rights today with regards to the potential to be represented by counsel. We've had this conversation before, correct?
I do not consent to any statutory authority presumed by this court.
Okay. We've had that conversation before about your right to have an attorney?
I am representing the all-caps name, Your Honor. I am the attorney.
No, you cannot do that unless you have been issued a P number by the state of Michigan that legally authorizes you to represent another person in court, and it often seems that the more time sovereign citizens are given to speak, the more they invent these so-called special appearances that have no basis in actual law or recognized legal procedure.
Do you want to have an attorney assigned to you?
No.
All right. You understand that if you wanted to, the court would have the Michigan Indigent Defense Counsel assign you.
I understand that.
Okay. You understand also the challenge of the crime that you're charged with?
Yeah, I don't understand that.
The maximum penalties? It's a felony charge of non-sufficient funds check that occurred on or about May 31st, 2024. Maximum penalty is up to 2 years in prison and a $2,000 fine or 3 times the amount payable, whichever is greater. You've heard all of those maximum penalties before?
I have.
You have any questions about that?
No.
And having heard those maximum penalties, is it your request today to proceed on your own without counsel?
Yes.
Okay. You know that I have to treat you as if you had an attorney, correct?
Yes.
Okay. You know that I can't assist you in any way as we go through this hearing. You're going to have to question witnesses on your own. You make the decision on whether or not you want to testify. You understand all that.
I do have the right to question.
You do? Yes. Okay, you do. But I won't be able to help you with that.
Right.
You understand that? Okay. Have you ever gone through a court hearing previously where you represented yourself?
No.
Okay. Have you looked into what a preliminary exam entails and exactly how this is going to go procedurally?
You briefly explained it to me last time we were here.
Okay. Do you have any questions right now about the process?
Well, my first question is, my question really regarding the whole thing is, I don't know if she is,
Who's she?
the prosecuting attorney is capable of even speaking.
I'm not sure exactly what you mean. My question was about a preliminary exam. I'll let you can make your motion here in a moment if that's what you didn't have, but are there any questions about this preliminary exam?
No.
Knowing all that, all the understanding and explanation that I just gave you, it's your decision today to proceed on your own.
Yes. Yes.
All right. You want to bring up a couple issues?
Yes, I have an issue with the fact that under the bankruptcy of the United States of America, does the prosecutor have bonded fiduciary or sworn trust? Does she act as a prosecutor with bonding and act as a trustee for the United States? So is she able to do?
Yes, if she is the district attorney, then she was either elected or appointed to that position and has the legal authority to represent the state in criminal cases. Her role is not merely symbolic, it carries real power in the courtroom, including the authority to file charges, present evidence, and ensure that cases are handled according to the law. So, when someone attempts to challenge that authority without any legal foundation, it does nothing to affect her position or the duties entrusted to her.
Yes.
Okay. I'm not going to answer any questions. You have a motion that you want to make. Are you challenging something? And
yes,
saying that the court should move in one direction or another? I'll make a decision on that.
I would like to make a motion to challenge the validity of the prosecutor being able to prosecute this thing.
Okay. Based on what? I'll give you a chance. Based on what?
Based on the bankruptcy of the United States of America,
Okay.
Because is she a trustee for the United States of America? That is my motion.
All right. Ms. Lee?
Thank you, Your Honor. Your Honor, I'm a licensed attorney in the state of Michigan. I am employed by the county of Oakland, and I have authority to exercise my prosecutorial duties within any district court within the county of Oakland. Furthermore, Your Honor, this charge is not anything that has been charged federally. Otherwise, there would be a federal prosecutor here. This is a county level from the city of Berkeley. So yes, I do have authority to move forward with these charges because the charges did come from my office, which is at the state level.
All right, and I reviewed the complaint prior to today's hearing. It complies with the Michigan court rules and the statutes that are at issue. Mr. Chauvin, you made an objection. It's been being recorded on the record. The court's denying your objection, denying your motion. Have another motion you want to make? Are we ready to go?
Yes, I also have a motion for denial of process, that this should not even be taking place because I was denied access to documents, records, by making me pay for a fee for copies, which is against the Constitution.
What copies did you have to pay for?
Copy of records.
Which records?
My court filings.
Your court filings?
Yeah, that I submitted.
You needed copies of the documents that you submitted?
Yes, certified copies.
Did you get those?
I had to pay for them.
Okay.
There should be a judicial notice, I guess.
I have something here with me. Did you get anything?
I did not hear it.
Did you want to review this?
May I approach, Your Honor?
Any response to what he's talking about?
Your Honor, I mean, with regard to getting certified copies, everybody has to pay for those, so I'm not entirely sure where the issue lies. Furthermore, they're his documents, so I'm not entirely sure why copies were needed to begin with. So I also have nothing to do with whatever fees are issued by the court.
Sure. So those fees are, again, set by court rule and statute, your objection to the court imposing those fines, or not fines, but fees to get the copies, those are overruled. The court's just following the court rules with regards to that. Your motion is denied with regards to the impact it may have on your due process. If it did have any impact, it would be a negligible one, given the fact that they were the documents that you had submitted. And the court register of actions would just simply confirm that they were actually submitted, which you could have also done by bringing your own second copy, having a true copy made, or a stamped copy returned to you that way. But in any event, I don't believe it has any impact on the way that we're going to proceed today. So again, you made your motion. There's a record of it. I denied it, and we're going to move on from there. So did you have any additional motions?
Yes, I have one more motion. I think that this case should be totally thrown out because there was no legitimate warrant, sir. No legitimate what? Warrant.
A warrant. Okay.
Which is why we're here in the first place.
No legitimate warrants.
No lawful warrant. I apologize.
Before I let you respond, what are your objections to the warrant that they would make it unlawful?
Well, I was notified of a hearing to have the warrant issued, and under law, Public Act 1957, I'm allowed to be at a hearing where a warrant is issued in my name.
Were you denied access to the hearing?
I've never received a notice.
Okay. All right. Continue.
Your Honor, the warrant was issued by the office. It was sworn to by the court, entered into the system. I believe that there is not only case law, but statute, Michigan law, that allows for that to occur without having the person being charged present.
I agree. I'm going to, again, deny your motion. You made a record of it, though. And that's the court's ruling. So any additional?
No.
All right. Then everyone can have a seat. And did you want to call your anything from you?
Yes, Your Honor. I would just ask for a mutual sequestration. I'm not sure who this individual in the court is.
Okay. Who's in court with you?
This is my wife.
Okay. Is she a potential witness in the case?
Your Honor, is this Kimberly Chauvin?
Yes.
She's listed on here as a witness, so I'd ask that she be sequestered as well.
Okay. Any comments about that request?
She kind of helped me with counsel, though. So
okay. She can't do that. She's not. Is she an attorney?
No.
Okay, so she can't do that, so that's not a basis for me to deny the request. So the reason that we'll have everybody step out on both sides, so any of your witnesses except for the officer in charge would also need to be out in the hallway, is that all the testimony will then occur and I will be able to hear it and have that influence the way that they're going to testify. So on that basis, the motion to sequester witnesses is granted. So Ms. Chauvin, you'll need to step out in the hallway and we'll get you when it's your turn to come to the testimony. Okay? All right. Your first witness.
Thank you, Your Honor. Chief of Matthew McBride.
If there are no further questions on the record, the court may proceed and treat the statements as uncontested, but relying on silence as agreement is a risky approach, and it rarely works the way people expect in a courtroom.
All right, so before you get seated, please raise your right hand. You solemnly swear or affirm the testimony you give today will be the truth, the whole truth, and nothing but the truth. I do. Put your hand down and have a seat. Once you do get seated, if you state your first and last name and provide the spelling of both for the record, please. Oh, jeez. Sorry. Tony's.
Sorry. Matthew McBride, MATTHEW MCBRIEN.
Go ahead and say you.
Thank you, Your Honor. Mr. McBride, where are you employed?
Credit Union 1, Berkeley.
And what is your job?
I'm a teller.
I'm going to draw your attention to May 31st of 2024. Were you working that day?
Yes.
And are you familiar with a Robert Chauvin? Did
Yes.
you see him in the courtroom here today?
Yes.
Can you please point to him and identify something he's wearing?
I guess a pale shirt.
Thank you. Your Honor, let the record reflect that the witness has identified the defendant. I'm showing you what's been marked as People's Exhibit 1. Please take a look at that. And is that a copy of the check that was provided to you on that date?
Yes.
Did he also provide a copy of his ID?
Yes.
And once he provided copies of the check and his ID, what happened next?
So he did, I handled deposit and then he wanted to do multiple cash withdrawals.
And did you provide the withdrawals to him?
Yes.
And how were they provided to him?
In envelopes, like different denominations.
Okay.
Usually ask for certain amounts in separate envelopes, so.
And it was cash?
Yes.
So the check that was provided to you, what was the amount on that?
It was 30,000.
30,000. Okay. And how many withdrawals were made?
7.
Okay. And what were the amounts of the withdrawals?
So one for $1,024, $960, $1,500, $600, $1,200, and $2,000.
All right, Mr. Chauvin, you have the opportunity to cross-examine this witness. I have no question.
What is difficult to understand is the reasoning behind the decision in this case. If there was never any plan to cross-examine witnesses or present defense witnesses, then it raises the question of why self-representation was chosen at all. At the very least, an experienced attorney would have been able to challenge testimony, raise proper objections, and present a structured defense that could have meaningfully affected the outcome.
Ms. Taylor, before you get seated, if you'd raise your right hand. You solemnly swear or affirm the testimony you give today will be the truth, the whole truth, and nothing but the truth.
Yes. Ms. Taylor, where are you employed?
Credit Union 1.
And is that in the city of Berkeley?
I used to be the manager in Berkeley. I'm now at St. Clair Shores, but I was, yes.
Okay. I'm going to draw your attention to September 5th. Did you contact, of 2024, did you contact Berkeley PD?
Yes.
Why did you do that?
Our risk management department sent over a packet to send down to them. So when they knew that, they just send it to the branch manager, we call and hand that over. It was, from my understanding, it was because bad checks had been passed and was causing us a loss, so they were sending that down.
And the person who had deposited those checks, were they notified to your knowledge?
I believe so, yes.
Objection, Your Honor, as you're saying.
Did you provide a packet from your loss prevention to Berkeley PD?
Yes.
So you gathered everything up and gave it to them?
They gathered everything up, so they sent me the packet complete. I don't actually.
So you just, okay.
Yes, I just handed it over.
Okay, thank you. Your name?
All right, Mr. Chauvin.
Your name, nothing for this.
Mr. Chauvin, any questions for the detective?
Yes. I'm sorry. on the date we spoke on the phone, did you have any intent, or did you think I had any intent to defraud the bank?
Objection, Your Honor, calls for speculation.
Same.
All right, I have no more questions.
Ms. Mr. Chauvin, do you have any witnesses you were calling?
No.
And ask find over.
Your Honor, people who provide over charge reserve any argument for them.
Mr. Chauvin, any comments about bind over?
Yes. So to bind over is to go to circuit court, correct?
Correct.
Okay, so I do have one question though. In my attempt to cure debt, I attempted to deposit a bill of exchange, which is lawful, and they rejected it. So why is that not taken into consideration here?
Okay, so your argument is that you tried to cure the debt, and so for those reasons, the case should not be bound over.
Yes.
Your Honor, I would just indicate for the record, you did testimony that the bill of exchange that was presented by Mr. Chauvin was indicated to be not accepted as tendered legally to the bank. Furthermore, Your Honor, that's a question of fact, not a trier of fact.
All right. The court's heard the testimony from the witnesses today, the arguments of the parties. I find that the testimony provided by the two witnesses from the bank and the detective do meet the probable cause standard required at the preliminary exam to bind over this matter to the circuit court. Mr. Chauvin, you brought up a potential trial defense. That's an argument that you could make later on down the line. But as of today, that is a question of fact and whether or not that was an actual legal tender that you had provided. It's not a basis to deny the bind over. So that's something that we'll continue to move on down the line here. I find that the testimony met the burden. So count one is bound over to circuit court for further proceedings and fines.
All right, I know the audio is not very clear, and some parts of what the judge said may have been hard to hear, but this was a bind-over hearing, which is a probable cause review to determine whether there is enough evidence to move the case forward to circuit court for trial. I wanted to clear that up. So, it does not leave things confusing, especially after hearing those sovereign citizen arguments. Thanks for watching. If you enjoyed the video, hit the like button. If not, hit dislike and leave a comment and subscribe with notifications turned on so you do not miss future content.